day everyone, we're the presenters from Group 2 and our topic is entitled The Data Privacy Act of the Philippines of 2012. So let's begin to our first discussion. We have what is the Data Privacy Act in the Philippines? Now, the Data Privacy Act in the Philippines, or the Republic Act number 10173, otherwise known as the Data Privacy Act, wherein this is the law that seeks to protect all forms of information, be it private, personal, or sensitive. Now, this law means to cover both natural or juridical persons that would be involved in the processing of personal information. Now, other than that, the Data Privacy Act in the Philippines is the 21st century law that would address the 21st century crimes and concerns. First, we have it protects the privacy of individuals while ensuring free flow of information that would promote innovation and growth. Second, it would regulates the collection, recording, organization, storage, updating, or modification or retrieval, consultation, use, consolidation, blocking, erasure, or destruction of personal data. Other than that, it ensures that the Philippines complies with international standards set for data protection through National Privacy Commissions or the NPC. Now, going to that. Next, we have who does the DPA apply to, or the Data Privacy Act. Now, the DPA applies to both individuals and legal entities, or both data controllers or the data processors. Now, they are defined by the GDPR. So, the definition of GDPR will be followed up by the discussion for our next reporters. Now, going back, like the GDPR, organizations outside of the Philippines who process the personal information of the Philippine citizens or residents might also comply with the DPA. The DPA covers businesses within the Republic of the Philippines and organizations with the Office of the Philippines. But unlike the GDPR, it also includes those who use equipment located in the Philippines. Okay, so next we have, for our next one, we have who implements the DPA or who implemented the DPA. Now, the answer for that is the National Privacy Commission or the NPC. Now, the NPC is in charge of administering and implementing the DPA. Now, the NPC is also tasked to monitor and to ensure the compliance of the Philippines with international standards for personal data protection. Next for that, we have President Benigno S. Aquino III signed the Republic Act number 10173 or the Data Privacy Act of the Philippines of 2012 on August 15, 2012. Other informations for the DPA or the Data Privacy Act. Now, the Data Privacy Act of the Philippines of 2012 is the first law in the Philippines that acknowledges the rights of individuals over their personal data and enforcing the responsibilities of entities who process them. So for our next reporter, we have Ms. Russell Casiple.
Good day everyone, my name is Russell G. Casiple and I will be discussing the continuation of our topic entitled Legal Guidelines and Law Guidelines in Data Privacy. The first question is, what does the DPA consider to be personal information? Followed by what individual rights are given to Philippine citizens and residents? And the last is, what are the penalties for the non-compliance with the DPA? So what does the DPA consider to be personal information? So the DPA considered personal information such as the following. First is an individual's race, ethnic origin, marital status, their age, the color, and the religious and philosophical or political affiliations, followed by the individual's health, education, genetic, or sexual life, or any proceeding for any offense committed or alleged to have been committed by such person, the disposal of such proceedings or the sentence of court in such proceedings. Third, informations are the issued informations by the government agencies particular to an individual, which include social security systems, previous or current health records, licenses or incidentals, suspension or revocation, and tax returns. And last is the information specifically established by an executive order or an act of the Congress to be classified. Second is, what individual rights are given to Philippine citizens and residents. So first right is the right to dispute. This right provides subjects with ability to contest inaccurate data with the data controller and to request for the information to be corrected. So here is an example. A government employee resigned from her agency with a period with premium payments of 20.49 years. The employee's birth date indicated in her Government Service Insurance System or GSIS records is 30th of June 1959. So however, her National Statistics Office or the NSO authenticated certificate of live birth shows 30th of June in 1952 as her birth date. Her birth date will determine when she will start receiving her monthly pension. So in 2019, if based on the GSIS record, and in 2012, if based on her birth certificate, she thus invoked her right to rectify her personal data under the Data Privacy Act of 2012. So that is an example. So next right is the right to erasure or blocking. When we say right to erasure or blocking, according to the regulation, data subjects can suspend, withdraw, or order the blocking, removal, or destruction of his or her personal information from the controller. So to exercise this right, the data subject must have substantial proof that the data is incomplete, outdated, or false, or was unlawfully obtained. This right also states that data subjects will be compensated for any resulting damages. So under this law, you have the right to suspend, withdraw, or order the blocking, removal, or destruction of your personal data. So you can exercise this right upon discovery and substantial proof of the following. So here are the following. First is your personal data is incomplete, outdated, false, or unlawfully obtained. Followed by the number 2, it is being used for purposes you did not authorize. Number 3 is that the data is no longer necessary for the purposes for which they were collected. Followed by you decide to withdraw the consent or object to its processing and there is no overriding legal ground for its processing. 5 is that when the data concerns information prejudicial to the data subject, unless justified by freedom of speech, of expression, or of the press, or otherwise authorized by court of law. 6 is the processing is unlawful. And the last is when the personal information controller or the personal information processor violated your rights as the data subject. So here is an example. In Melvin v. Red 34, decided in 1931, for example, a homemaker who had once worked as a prostitute and who had been wrongly accused of murder became the subject of a feature film, The Red Kimono, 7 years after her acquittal, based on facts of her trial. So although not specifically referencing a right to be forgotten by the court, permitting suit against the filmmaker noted, one of the major objectives of society as it is now constituted, and of the administration of our penal system is the rehabilitation of the fallen and the reformation of the criminal. So the court held that the unnecessary use of the plaintiff's real name inhibited her right to obtain rehabilitation. So that is an example. So how to exercise your right to erasure or your right of blocking? First is, what you are going to do is to execute a written request to the organization addressed to its data protection officer or the DPO and have it received. In the letter, mention that your request is being made in exercise of your right to erasure under the Data Privacy Act of 2012. Documents to support your request must be attached. The DPO must act on your written request. In case if you feel your requests have not been addressed satisfactorily, you may file a formal complaint before the NPC. Attach there with your request letter to the DPO. Second right is the right to data portability. So data subjects have the right to request to their personal information from the data controller as long as the data was processed electronically. So what is the right to data portability? So the right to data portability gives individuals the right to receive personal data that they have provided to a controller in a structured, commonly used machine readable format. So it also gives them the right to request that a controller transmits this data directly to the controller. So when does the right time to apply this? So the right to data portability only applies when your lawful basis for processing this information is consent or for the performance of a contract, and you are carrying out the process by automated means. Example are the including paper files. So what is an individual entitled to? So the right to data portability entitles an individual to, first is to receive a copy of their personal data or to have their personal data transmitted from one controller to another controller. So individuals have the right to receive their personal data and store it for further personal use. This allows the individual to manage and reuse their personal data. For example, an individual wants to retrieve their contact list from a webmail application to build a wedding list or to store their data in personal data store. So, how can you achieve this? You can achieve this by either directly transmitting the request data to the individual or providing access to an automated tool that allows the individual to extract the requested data themselves. This does not create an obligation for you to allow individuals more general routine access to your systems, only for the extraction of their data following a portability request. Now let's jump on to the last, to which what are the penalties for the non-compliance with the DPA. So the DPA includes various penalties for individuals and organizations that are found non-compliant, many of which include imprisonment. Data controllers are held accountable for the following. First is the processing unauthorized data, negligent access, illegal disposal, concealment of breaches or intentional breaches, and the unauthorized or malicious disclosure of data. So here are the penalties to be given. So in an unauthorized processing of personal information and sensitive personal information, the penalty is that they shall be penalized by imprisonment ranging from 1 to 3 years and a fine 500,000 pesos to 2 million shall be imposed on persons who process personal information without the consent of the data subject or being authorized under the DPA or any existing law. Second is that in accessing personal information and sensitive personal information due to negligence. So, the penalty is they will be penalized by imprisonment ranging from 1 to 3 years and a fine of 500,000 pesos to 2 million shall be imposed on persons who, due to negligence, provided access to personal information without being authorized under the DPA or any existing law. Next is, when it comes to improper disposal of personal information and sensitive personal information, the improper disposal of personal information shall be penalized by imprisonment ranging from 6 months to 2 years and a fine of 100,000 to 500,000 pesos shall be imposed on persons who knowingly or negligently dispose, discard, or abandon the personal information of an individual in an area accessible to the public or has otherwise placed the personal information of an individual and its containers or for trash collection. So when it comes to unauthorized access or intentional breach, the penalty is imprisonment ranging from 1 to 3 years and a fine of 500,000 pesos to 2 million shall be imposed on persons who knowingly and unlawfully violating data confidentiality and security data systems, breaks in any way into any system where personal and sensitive personal information is stored. So the last is when it comes to malicious disclosure, any personal information controller or personal information processor or any of its officials, employees, or agents who, with malice or in bad faith, discloses unwarranted or false information relative to any personal information or personal sensitive information obtained by him or her, shall be subject to imprisonment ranging from 1 to 6 months to 5 years and a fine of 500 to 1,000 to 1 million pesos. Okay, so that ends my report and I hope you do understand that topic. Thank you for listening.
Now let's move on to GDPR, or General Data Protection Regulation. It is said to be the toughest privacy and security law in the world. The regulation became effective on May 25, 2018, replacing the data protection directives. And with these changes, the penalties for non-compliance increased. The regulation's purpose or aim is to create more consistent protection of consumer and personal data across EU nations or European Union nations, and to have uniform data security law in all EU members. And some of the requirements of GDPR includes requiring consent of subjects for data privacy, anonymizing collected data to protect privacy, providing data breach notifications, safely handling the transfer of data across borders, requiring certain companies to appoint data protection officer to oversee GDPR compliance. In conclusion, the regulation is about data protection and privacy in European Union and European Economic Area, which means that not only the members of EU are subjected to the regulation, but the other countries as well who markets goods and services to EU or European Union nations. Now, why is Data Privacy Act important? As we live in digital world, it is important to have data privacy acts or laws. And according to the National Privacy Commission, the importance of Data Privacy Act are: it protects the privacy of individuals while ensuring free flow of information. It regulates the collection, recording, organization, storage, updating or modification, retrieval, consultation, use, consolidation, blocking, erasure, or destruction of personal data. It ensures that the Philippines complies with an international standard set for data protection through national privacy.
It also prevents cybercrimes like identity theft, scams, and more. There are three persona involved in the Data Privacy Act, and these are the data subject, personal information controller, and personal information processor, wherein data subject is the identified or identifiable living individual to whom personal data relates.
It is an individual that can be identified via an identifier such as a name, an ID number, location data, or via factors specific to the person's physical, physiological, genetic, mental, economic, cultural, or social identity.
Next is personal information controller. It is a person or organization who controls the collection, holding, processing, or use of personal information.
Personal Information Controller controls the processing of personal information, including a person or organization who instructs another to process personal information on his or her behalf. The controller is the person who determines the why and the how of a data processing activity. Activities such as interpretation, the exercise of professional judgment or significant decision-making in relation to personal information must be carried out by a controller.
Lastly is personal information processor. It refers to any natural or judicial person qualified to act as such under this act to whom a personal information controller may outsource the processing of personal data pertaining to a data subject.
A processor is anyone who processes personal data in behalf of the data controller.
So, let's now proceed to the things that we need to protect when it comes to our personal information. Number one that we need to protect is our name. Second is our address. Third is our TIN number. Fourth is our SSS number, including our GSIS number. Fifth is our contact number. Sixth is our bank account details, including our account number, bank number, and CVC. Lastly, our LRN. First of all, you need to understand that you have a role in protecting yourself from identity theft. There is nothing more important than keeping your personal information secure so that you can prevent identity theft. This information is the gateway to your financial institutions, medical records, credit score, and other important personal information. So managing your personal data is first and foremost up to you. That is why we must stay vigilant and protect ourselves from people who are after our personal information. We all know that privacy is essential to who we are as human beings, and we make decisions about it every single day. That's why the National Privacy Commission imposes personal information controllers and personal information processors to implement reasonable and appropriate organizational, physical, and technical security measures for the protection of our personal data. To understand more, the National Privacy Commission is an independent body mandated to administer and implement the Act and to monitor and ensure compliance of the country with international standards set for personal data protection. Now, in order for us to protect our personal information, we need to know our rights. What are they? First is our right to be informed. Your personal data should not be collected and processed without your permission. Second, right to access. This is commonly referred to as subject access. gives individuals the right to obtain a copy of their personal data, as well as other supplementary information. It helps individuals to understand how and why you are using their personal data and check you are doing it lawfully. Next is our right to object. What is this? You have the right to object to an organization processing or using your personal data at any time. This effectively means that you can stop or prevent the organization from using your data. Next, our right to erasure or blocking. Under the law, you have the right to suspend, withdraw, or order the blocking, removal, or destruction of your personal data. You can ask an organization that holds data about you to delete the data about yourself. Next, the right to damage. What is this? You may claim compensation if you suffered damages due to inaccurate, incomplete, outdated, false, unlawfully obtained, or unauthorized use of your personal data. Next is your right to file a complaint. If you feel that your personal information that has been misused, maliciously disclosed, or improperly disposed, you have the right to complain to that organization that using your information. Next is the right to rectify. You can correct personal data if it is inaccurate or incomplete. For example, you give your name to a particular organization and you write it wrong. You have the right to rectify or correct that information so that they will not misuse it. Next. And lastly is the right to data portability. What is this? Allows individuals to obtain and reuse their personal data for their own purposes across different services. It allows them or you to move, copy, or transfer personal data easily from one IT environment to another in a safe and secure way without affecting its usability. So, now that we know our different rights to our personal information, I hope that we can exercise it to protect our personal information. We will then now proceed to difference of data privacy and data security to be discussed by Jane Villamarin. Thank you so much for listening.
Good morning, everyone. Good day to the viewers. The next topic that we are going to discuss is the data privacy and data security. So data privacy and data security are two different things. Although they are both related into data, they are both different in some ways. So first of all, when we say data privacy, it is about ensuring who can process or who are authorized to access the data can do so. For example, we as a reporters, we have our own PowerPoint presentations, and our group, are able to access our G Drive, wherein we will input or we will upload the files that we need to upload in there, and that specific folder that is accessible by us. So that is data privacy. There are people that you know who can access the data that is related into all of you. But for example, as well in data privacy, it can also be yourself. For example, you have a photo in your cell phone, in your photos, in your files, and the data privacy is the fact that you are protecting other people or you are protecting the file itself to be seen by other people. So that is data privacy. You are protecting the data by the means of the people that you don't want to see it. You are protecting the data by means of creating or securing it by yourself by not having people see it because you don't want people to see it. So that is data privacy. It is the privacy of the data itself, from the word itself, data privacy. So again, it is about ensuring only those who are authorized to access the data can do so. There are no other people whom you whom you did not authorize to access your file, those people have no power to access your file because you did not authorize them. And if in that case, if those people access your data, then that is the what do you call this one? That is uh, punishable by the law. That's a term. So in data privacy, because we have the law, which is the Data Privacy Act, and when you ensure and when you make sure that those people whom you only allowed to access your data is the only people who are accessing your data, then that's fine. But if you knew that there are people who's accessing your data whom you did not authorize, then that is punishable by the law. And second one, data security. So the data security is the guarding the data against malicious threats. So this is very complex. This is very broad because when we say about technology, there are lots of malicious threats that we can see. For example, this is one example on our personal computers, on our cell phones. We store files on our cell phones and on our personal computers. And also, we all know that our computers have this application which is called the Windows Security stuff, if I'm not mistaken, Windows Security, something like that. And you can also install other protections in your computer. And the main purpose of it is to avoid other people or avoid viruses that will come into your personal computers. So with that being said, that is the data security because you are guarding the data or you are guiding the data to not be accessed by those people whom you did not authorize to do so. So when we say data privacy, you are making sure that your data is private by those people whom you authorized to access it or by yourself. And when we say data security, it is the action that you're doing. It is the guarding of the data against those people or malicious threats. So the next topic is that we are going to discuss is the Data Privacy Act on social media. This is very crucial. This is very salient because Data Privacy Act is more likely more efficient in social media. Why? Because in social media, lots of people store information in there. And the only problem in social media is that in just one click, your information can go public. That is one problem in social media. And that is one problem in social media that that ignorance can trigger. So if you are ignorant in terms of how social media works, you are vulnerable in terms of letting other people to see the information that you wish to be private. So with that being said, here are the tips on how you are going to be secured and how you are be secured in terms of social media because that is very salient. That is very important as of today because in social media, as what I said earlier and as what I will said again and again and again, if we access social media and if we are vulnerable, we are or the other people are unstoppable already into accessing our data, and that makes us vulnerable. It's ourselves, so that will make us weak in terms of protecting our personal data, our personal information, and that is very dangerous. That is very, very dangerous because, for example, you have an SSS number, you have a phone number, Gmail address, and so on, some information that is related into accessing you or contacting you. And when other people saw that, it's kind of like it makes you vulnerable. That's the only thing that I can say. It makes you vulnerable. In fact, I have this one experience, and I'm still experiencing it as of today until today. I have uploaded my phone number in Facebook, and I know you're also into this one. But my only wrong is that I uploaded my number in those who are seeking or asking if I need a job. In that, I have uploaded my number, and what's happening until now is there are lots of people that have contacting me, that is texting me about they need a job, and The only thing that I can do about them is to block them or to ignore them because I cannot change my phone number. So that is what I was experiencing as of today because I was not aware, and that is my fault. And that is what I assumed, and that is what I wish to know when I was in that specific time. So with that being said, here are the tips for us to avoid that. First, be mindful of what you store and share. This is very crucial. This is very salient. Be mindful of what you share because although other people cannot see the data that you store in social media, the developers and those people who are or who created the social media itself, they can see it. To be honest, they can see it because they keep track on what we store on our social media and they can see it, and it's up to them if they will use it against us, or they will make sure that that data about us is ensured or secured. So the next one is be careful on whom you trust. This is very salient as well because in social media, chattings or DMs are very, it is now the trend. And with that being said, be careful on who you trust. For example, I have one friend. We are friends, we are best friends. And I chose to send him or her the data or the information about me that will make me vulnerable. For example, my SSS number. And I sent it to her. And for some instances, for example, she used it against me. So that what makes us vulnerable. So be careful on whom you trust. And third, if possible, avoid storing special data on social media at all. Do not store data that is important to you at all on social media because we can store that in different places aside from social media. For example, on our personal computers, on our cell phones, without uploading it into social media. We can do that. That will make us not, or that will not make us vulnerable because that will be private. That will be still within ourselves. So the next one is not everything about life should be posted, most especially your current location. And yeah, but if you can post it, if you don't have any fears at all, but you can post that stuff because that is your social media, that is your choice. But not all of the time we should post everything that we want to post because with that being said, privacy is always what we say, that privacy is always salient. And if we post everything on social media, then we are giving up on our own privacy. So lastly, think wisely before you dive into the deep ocean of social media. Think wisely. Think again and again and again. Think 100%. Use the 100% of your mind in deciding if you will post or if you will upload this kind of information. In this kind, you have to really think wisely. Because if not, one mistake can change everything. One mistake can change everything. That's all I can say. One mistake can change everything. So for the last bullet, think wisely before you dive into the deep ocean of social media. So the importance of Data Privacy Act in digital world. So why do we have to create, or why do we have to implement Data Privacy Act in digital world? As what I have said earlier, since Data Privacy Act have already been discussed by the previous reporter, all I can say is, why is it important in the digital world? As what I have said, all or majority of the people have already transitioned from traditional into digital world. And with that being said, learning new things on how it functions is not learned with just one sitting. It is not mastered with just one sitting. It has to be learned for over time or a period of time for us to be able to process it or to master it. And that is what we need in digital world, in social media. We need to master everything. Because if we do not, then we are vulnerable. And if we do not, we might commit mistakes that will makes us that will make us vulnerable itself. So the importance of Data Privacy Act in digital world is that in social media, humans are not perfect. Humans are not perfect. We commit mistakes. Even though we already knew things, we still commit mistakes. And in social media and in digital world, I can also say, it only takes one click. It will only take one click, and sometimes that one click is not you cannot go back again and undo what you have done. Sometimes that's how digital world works, and sometimes it is not. If we are lucky, sometimes if we are not. But if you're unlucky, if we have clicked something that is malicious and that is a mistake, and we cannot undo it, then that is a problem. That is a massive problem. With that being said, Data Privacy Act is important in digital world, because even though we commit mistakes, because again, we are just human beings, we commit mistakes. So Data Privacy Act is there to protect us, to protect ourselves. So Data Privacy Act will represent the law. And if we commit mistakes on doing something in digital world, the Data Privacy Act is the one who is authorized to protect us. It is the one who will correct our mistakes, because if we have committed a mistake from that moment, the Data Privacy Act will be processed upon law, and our mistakes will be processed with the use of Data Privacy Act and its salient features, and then we have a chance to correct what have been done. So that's how Data Privacy Act, how important Data Privacy Act in digital world. More likely, I can compare it into a vest that we use when we are in an ocean, when we are swimming, the vest to make us float. So that is Data Privacy Act. And digital world is an ocean of technology, and an ocean, or a whole new world, wherein we can explore. And with the Digital Privacy Act is our vest that will protect us to not yeah. So that's it. So that is the importance of the Data Privacy Act in digital world. I hope you learned something with our group. Thank you, everyone, and have a nice day.